the applicable laws and rules. And as is said, this is to be an introduction, because I understand that there will be much more in-depth discussion later on. Now, in order to start, as it were, the historical development, I think if one is talking about the historical development of ADR, one perhaps can start with actually many, many years ago, when the whole society is really using a negotiation and what we now call mediation form to resolve any disputes that they have. And so therefore, I think if one is to look at that, one has a very long historical aspect to look at. But if we are looking specifically here at the development of arbitration, I think we can look at it in something closer to time, a lot closer to time, maybe a few hundred years, and then we'll be able to resolve it. Because as you all know, for example, in China, the resolution of disputes in the villages, which have been in tribes in other places as well, have been using mediation. And it's much, much later that they started to have arbitration as their way of resolving disputes. Insofar as if I can therefore limit and shorten the topic of historical development of ADR to that of arbitration, and then we'll come and look at the definition and essential characteristics of ADR later on. If we focus on the historical development of arbitration, I think we can start by looking at the time frame and looking at how contentious proceedings began. It's important to appreciate that the constitutional forum to resolve disputes is in the national courts, and that is something that is given that's a power that is given under the constitution of the relevant country, in which they would then be able to resolve the disputes of their subjects under the constitution through this system of litigation. So this is where all litigation arrangements begin. Now, insofar as arbitration, one perhaps can look at it and understand it in the context. My screen is still not working. I don't know why. Can you just pause one moment? Sorry, apologies for this technological glitch. I was starting with the constitutional order, whereby courts are the dispute resolution forum, and then they will deal with the disputes when they arise in terms amongst the subjects. After that, there were then resolutions, or there were then preferences of the people, including the enterprises, who would like to resolve their disputes using private mechanisms. And therefore, they decided to use what we now call arbitration, effectively the two of them agreeing to engage a third party to resolve their disputes fairly. So that sort of agreement started in what we would now call ad hoc arbitration. They would like to do that because it is more closer to their economic sector. They understand the people and they trust the people. It's quicker, it's faster, and you don't have to go through all the rigmaroles like in a national court. So that was why, and that was how ad hoc arbitration began. It began hundreds of years ago, and looking only at the English case law, and of course I do not know about some other jurisdictions. It could go on to the 1800s, and some say even the 1600s, in terms of the era when first recorded some sort of historical studies on that. Now, of course, that is something that one can go and study, and there is a book about the history of arbitration. I do not need to go into that, because I think it's only enough for us to understand the history to reflect what is in the future, what is in the present, and therefore looking into the future. So therefore, in short, from national courts, we then have what we call ad hoc arbitration, namely, on an ad hoc basis, people agree to resolve their dispute using a private judge. It's a private judge because that person is expected, as we now call the arbitrator, to resolve the disputes according to the law. They would be less rigid, and so on and so forth. When that started to pick up, history shows that people, or rather the national courts, are rather, some would use the word envious, some would use the word skeptical about this private dispute resolution mechanism. So therefore, the national courts and the arbitration sector were not, as it were, working closely together. A lot of criticisms were levied against this private dispute resolution mechanisms, and people therefore cannot easily get their awards enforced, nor can they easily have assistance from the national courts. Insofar as and allowing the enforcement mechanisms to take place, at that stage there is no treaty as we now have. So they will have to rely on current national laws, such as contract law, relying on concepts of implied term in order to enforce the arbitral awards. That is, in order to give business advocacy to this arbitration agreement, it must mean that the parties have agreed to comply with the results of this arbitration. Otherwise, it would be meaningless to have such resolution clauses. So therefore, it was building up in this sort of way, and it was never entirely a very supportive national courts generally at that stage. In the international community, round about the 1920s, the ICC, the International Commercial Court, started to gather together a group of people who wished to look at how they could make their awards to be more enforceable, and to try and get something that will be more supportive of arbitration. The history will tell you that we started off with the Geneva Protocol in 1923, and from the Geneva Protocol, we will then have from the Geneva Protocol, we then have later on in 1958, the New York Convention. Now, during this stage, from the 1920s to the 1958, the arbitration community is facing a lot of uncooperative situations or views or approaches from national courts. And that has made the use of arbitration not as user-friendly or not as effective. And during this time, there are cases if one is to look at, for example, the English case law, looking at how they would look at the arbitration, and little bits of development coming through. But the real breakthrough really comes in 1958 in the New York Convention. Because even though the Geneva Protocol back in the 1923 also provides for enforcement of arbitral awards, somehow it never got off the ground. Maybe it's the timing, maybe it's the mechanism, which is not as user-friendly as the later New York Convention. So by 1958, this group of people started to gather together in order to look at how arbitral awards is to be enforced. Now, one must bear in mind this is 1958, at a time when arbitration is still in its early stages, and the only thing they were really looking at that stage was actually the enforcement of arbitral awards to begin with. So they have a lot of discussions, and ultimately, as we hear from Professor Albert Jan van den Berg, who is the PhD candidate student with Professor Peter Sanders. I think Peter Sanders, who was, as they say, sitting in the back garden and with a typewriter, typed out a simple version of New York Convention that really started the discussion that led to the current New York Convention that we have. I know that you will be having some further discussions about that, so I think enough for us to know that this is where the international arbitration community putting things together really pushes the effectiveness of arbitration forward. Now, insofar as this New York Convention is concerned, as we now know, there is, of course, also, apart from Article 5, which deals with enforcement of arbitral awards, there is also Article 2, which deals with the arbitration agreement. This enforcement of arbitration agreement was if one looks at the Trevor Preparatory of the New York Convention, was put in rather late. It was put in towards the end, but still, actually, it became actually more important in supporting and ensuring that the court supports arbitration than the latter part, which is the enforcement of arbitral awards. Because what it provides in Article 2 of the New York Convention is that if a case goes to the court, and if there is an arbitration agreement that is applicable, then unless it is null and void, incapable of being performed, etc., the court will have to refer that particular dispute to arbitration. Now, this is actually become a very important process. We in Hong Kong would call it, you would stay the dispute for arbitration, and in other places they would be suspending the litigation and various phraseology. But the idea comes from Article 2 of the 1958 New York Convention. This New York Convention, this particular provision becomes actually we'll come on to that in a moment, in the historical development of arbitration, a very important feature as well in the UNCITRAL model law. So that sort of puts ourselves now into the time frame in 1958. And of course, because the New York Convention is a treaty, in an international treaty, for those who have joined, will have an international obligation to implement it. In other words, the national court, as an organ of the state, will have an international obligation to refer the dispute to arbitration or to enforce the award unless certain grounds set out in Article 5.1 are provided. So that becomes a very important international legal framework by which arbitration really takes its form and really consolidates into something that becomes and really started to become more widely used. Now, coming back to China, for example, in CIETAC. CIETAC was set up, and I will be corrected by Brett if I got the year wrong. It's in 1956, actually before the New York Convention was formed. So in China, the arbitration has begun immediately with institutional arbitration. We'll make the distinction a little bit later on, but I'll point that out first. So therefore, that's what mainland China has started, and that's where CIETAC has begun. Now, if we may, since we're looking at the Hong Kong arbitration law, I would perhaps like to suggest we look at the history of Hong Kong's arbitration. The history of Hong Kong's arbitration, I would like to give it a complete and a more comprehensive view rather than snapshots. And it's important in that sense because if you weave everything together and if one is to study how Hong Kong has become a successful arbitration center, they all merge together in an interweaving way together and supporting each other. Now, Hong Kong. As you all know, prior to 1997, Hong Kong was under the British rule. And under the British rule, we adopted the common law. And of course, after 1997, we continue to use the common law. Now, under the British rule, a lot of our ordinances is actually based on the English Acts. And a lot of the ordinances we learned and borrowed from what has been done in England. And so, for example, in terms of arbitration, we learned and we borrowed that from the English Arbitration Act. The first arbitration legislation in Hong Kong was made in 1963, the Hong Kong Arbitration Ordinance. That particular arbitration ordinance was based on the 1952, and there were some amendments, 1932, 1950 English Arbitration Act. And in that particular time frame in Hong Kong, Hong Kong's arbitration does not distinguish between domestic, international, foreign related. The only thing they have is with a seat in Hong Kong. So therefore, that whole ordinance provides and deal with Hong Kong arbitration as the sort of mechanism that they are addressing. Under that particular provision, under that particular ordinance in those days, in England, using the English Arbitration Act, the arrangements was primarily, if I focus on setting aside of arbitration award, primarily was something that is akin to what we call leave to appeal on points of law. So at that stage, that was in the early stages, 1963, where there is a case that needed to deal with a question of law. There is a procedure called case stated, in which you go to the court and ask the court to decide that question of law and get it back to the arbitral tribunal for the tribunal to then consider and move forward. So it was a very interlinked procedures between the arbitration on one hand and the courts on the other. There is also the setting aside, as I was saying, leave to appeal on points of law, is that where an arbitral tribunal got an award and he wrote it in a way on a particular point of law that is what we would call so wrong that he could not be right, obviously wrong, and those sort of phrases, then if it is a point of law that is of general importance in a particular commercial sector, then the parties may take that allegedly erroneous point of law to the courts in Hong Kong and have it corrected so that the arbitration award can be revived or corrected or remitted back to the tribunal for decision. So 1963, just Hong Kong arbitration, and then having, if I use setting aside as an example, setting aside in general terms, but more importantly, in general terms, it's primarily on leave to appeal on points of law. The concept of setting aside for due process is there, but it has not really come into use at that stage. So 1963, this is Hong Kong. In the international world, in 1985, there is the UNCITRAL model law. The UNCITRAL has, based on the New York Convention, and then developed the model law on arbitration. That model law is another very important international legal framework that has set international arbitration into another era. The New York Convention has two main provisions: stay your litigation in favor of arbitration, enforce a pro-enforcement approach to enforcing the arbitration award. Come to the UNCITRAL model law, which is 1985. They've actually promulgated this model law by which the parties by which states can adopt and make it into their own national law and then become an internationally accepted practice or a jurisdiction which is internationally accepted with a regime that most states have discussed and understood. Now, it's also important to understand that the model law was actually based on the UNCITRAL arbitration rules, which came out in 1976. So the UNCITRAL arbitration rules was first drafted as an arbitration rules that ad hoc arbitrations can adopt, and then come the UNCITRAL model law in 1985. Now, as I said, the real landmark is still the 1985 model law, because this is where states can adopt the model law and become what we now call model law jurisdictions. In the model law, the important thing that comes out from that legal framework is that in Article 1, it talks about what is international. Because the model law was drafted in a way, because it's under UNCITRAL, the United Nations Commission for International Trade Law, involving a number of states to discuss what should be adopted, what is the model for arbitration. So therefore, it is obviously looking at international arbitration as the concept, and of course also looking at international commercial arbitration. And so therefore in Article 1, you see how they define what is international, and there is a footnote that tells you what is intended to be covered when it is said to be commercial arbitration. So that became the model framework, legal framework for international commercial arbitration, 1985. So from international, let's come back to Hong Kong. So what is happening in Hong Kong after 1963? In exactly the same 2 years that I've mentioned, 1976, Hong Kong has set up the first branch. It used to be called the Hong Kong branch of the Chartered Institute of Arbitrators that provided a number of training for arbitrators, arbitration practices, and so on and so forth. So that was, in a way, really bringing arbitration training into Hong Kong, where people started to know and have a better culture of arbitration. And here, if I may add, Hong Kong is the first in the Asia regime that has this branch. And in fact, I always say that we have the longest historical experience, but also a very strong culture of arbitration. So that was 1976. In Hong Kong, in 1985, another thing happened, and that is the establishment of the Hong Kong International Arbitration Center. Now, at that stage, the Hong Kong International Arbitration Center is a center that promotes arbitration. They have a room, a hearing room that they can rent out in order to provide services to the arbitration community. It's not like CIETAC, not an administered arbitration body. 1985, it's just a body that promotes and provides rooms, hiring or renting out hearing rooms for parties in arbitration. So 1985 is what happened. 1976, Hong Kong. 1985, Hong Kong Arbitration Center. Then I think round about that time, people realize here in Hong Kong, we realize the importance of the model law. And therefore, legislative work were brought in place in order to incorporate the model law and adopt it for use in Hong Kong. So after some legislative work and discussions, in 1990, Hong Kong adopted, or rather promulgated, its second arbitration ordinance, and that second arbitration ordinance came out in 1990. In this arbitration ordinance, Hong Kong adopted a dual system, meaning it has a system or a framework of arbitration laws and laws, if I call it that, that govern domestic arbitration, and another set of arbitration laws that govern international arbitration. The law that govern international arbitration is easy. If you look at that particular ordinance, you'll see that there's only literally one sentence in it, and that is will adopt the model law. Very simply, the whole model law was brought into place into Hong Kong and become Hong Kong's Hong Kong's international arbitration legal framework. The domestic regime was dealt with in the same way as it was in the 1963 arbitration ordinance. Namely, it is still there. You have appeal on points of law. Some older provisions like case stated have gone, but appeal on points of law become the main feature in domestic arbitration, which is quite different from the international regime, because in the international arbitration, we only have setting aside, and the substantive merits are never touched or dealt with, as you will no doubt be hearing more about how the model law is worked out and how it is framed. So Hong Kong then moved on to this dual regime. And when this dual regime came about, a number of important things have happened in Hong Kong. The distinction between domestic and international arbitration became a question that has led to a number of court cases, but that was very easily ironed out. There were also cases where it's actually a truly international arbitration, but parties did not know about it, including the arbitrator wasn't aware of it, and they conducted it as if it's a domestic arbitration. By the end, when they come to look at how to deal with the award, how to challenge the award, then they realize, and then the court say in that case, you cannot by conduct change the very nature and confine it to the setting aside provisions. So all these cases have sought out a number of them fairly quickly and settled the dust, if I call it that, the distinction between domestic and international arbitration. So that is the dual regime. Now, the cases in Hong Kong at that stage still ad hoc, and those who were already involved will see the growth of international arbitration already picking up, meaning states or countries or jurisdictions who are not related to Hong Kong have started to use Hong Kong as the seat of arbitration. Now, at that stage, we talk a lot about finding a neutral seat. The way one talks about it is if you go to country A, if there's if there is a company in country A, another company in country B, you would go to country C for for arbitration because it's neutral venue and neutral arbitrator. Nowadays, that is no longer as important because the important thing is that the arbitral institution, the arbitral body, provides you with a neutral choice, a choice of neutral arbitrators. And then the quality and the neutrality of the supervision court is being viewed because it's generally in the public domain. So this is sort of, as it were, moved. But, in the very early days of arbitration, people would say A and B should go to C, that sort of approach. Now, I think the idea is no longer that and should no longer be just that. And therefore, as we say that with Asia, business and commercial activities growing so much, it is time that we should all work together and see if we can ensure that the disputes that arise from the Asian economy can be resolved in Asia, not only for the businesses purposes, but also for time zone purposes, for culture purposes, and so on and so forth. So 1990, Hong Kong adopted the UNCITRAL model law for international commercial arbitration and retained the 1963 provisions for leave to appeal on points of law for domestic arbitration. During this time, the arbitration grew, and also because Hong Kong has adopted the model law, Hong Kong's arbitration practitioners started to be able to pick up the use of what is effectively an international legal framework, and therefore would be able to share and exchange views with the international community on international arbitration. And that became a very important matter for Hong Kong to grow as an international arbitration seat, because people would be able to see that the people in Hong Kong would be able to see that the people in Hong Kong have the knowledge of this international arbitration practice, and therefore they are very happy and willing to come to Hong Kong to arbitrate. So therefore, Hong Kong's arbitration started to pick up actually very much when the Arbitration Ordinance adopted the dual system. Now that, of course, continued. In 2006, now we go back to the international world. In 2006, the UNCITRAL amended its 1985 arbitration model law and introduced the new set. Under the 2006 model law, the main introduction is that of interim measure, including provisions dealing with how to deal with it on an ex parte basis, and also how 2006 model law jurisdictions would allow reciprocal enforcement of interim measures between these jurisdictions in their Article 17J. So 2006, this new provision came out. Hong Kong has also been more and more successful in international arbitration, and therefore even the domestic arbitration practitioners are able to pick up the international practices. The only difference, therefore, is just the leave to appeal on points of law in the domestic regime. The practice is very much merging. So therefore, in Hong Kong, we started to then look at the 2006 model law and amend the arbitration ordinance the third time, and this is the current arbitration ordinance. And in 2011, the third arbitration ordinance was promulgated, and that arbitration ordinance effectively reunify the domestic and international regime into one regime, so we no longer make that distinction, and everything is governed by the 2006 UNCITRAL model law. I mean, of course, the numbers of the arbitration ordinance changes, but that is the scheme of things. There were then a group of practitioners, in particular the construction sector, were very concerned that the leave to appeal on points of law is done away with. So after discussions, and as you now see in the arbitration ordinance, there is a schedule that allows people to opt into this particular schedule and retain the right to take the award to go to appeal on points of law in the courts in Hong Kong. So therefore, by 2011, we have a unified regime. So as I said, Hong Kong's arbitration development comes in three phases. 1963, where one looks only at the seat of arbitration is in Hong Kong. 1990, where we look at the seat, but we have domestic and international arbitration, a dual system. After a number of years of successful practice, 2011, we say we reunify, and we now have a unified regime. Domestic or international, it doesn't matter. But when you arbitrate in Hong Kong, you adopt the UNCITRAL model law 2006 version. So that is how Hong Kong's arbitration ordinance began. Now, if I may finish this particular story with what is happening in Hong Kong since 1990, before we I think we should now 10:40. I think we have a 5